we will begin the final section here of the forum, which is to engage in a panel discussion with some of the questions that we've had to come in. Some of these are clearly aimed at certain people, and in those cases, I will identify them. But otherwise, it'll be a free-for-all, whoever feels most qualified to answer those questions. So right off the top, in no particular order, this question concerns lift director responsibilities. And I guess, Tom, you certainly touched on this in your presentation, but this may also be a regulatory or a standards question. I'm not entirely sure, but the question is, does the lift director need to be on site during the entirety of the lifting operation?
Yeah, Graham, I appreciate that. So the way that ASME looks at that are those are roles and responsibilities, not people, that are required for crane operations. So if a crane is operating, that is a role that needs to be fulfilled during that time. So that means that, and it says on the job site. So that means they're not in their car driving home along the way and leaving the site without a lift director. But again, multiple people can fulfill that role of lift director on a job site. It's not a specific person, it's a role that needs to be assigned.
Graham, from a regulatory standpoint,
Yes,
we don't, OSHA really doesn't require lift directors except in certain, under certain conditions, and they're very specified, like when you're doing assembly, disassembly, or tandem lifts or something like that. We stayed away from defining the term critical lift, but those are, things that were in that list, the critical list. So it doesn't necessarily, that person has to be there to be able to make the necessary determinations and assessments as needed for the job. It's kind of been squirrely too, as far as how far can they drift away from the actual crane operation? How far can they get away? So there's no real solid answer to that, but we make those determinations based on the facts of that specific site.
And that's a very interesting perspective, obviously, from the regulatory side. I know, Scott, you had some statistics there with respect to general crane, the top 10 crane violations, which actually I'm not sure I've ever seen before, because usually cranes are buried inside your general top 10. But Garvin or Scott, do you have any stats available you can share regarding citations for lift director?
None that I can think of right offhand. We've had a couple cases that that we have weighed in on that were in litigation with lift director issues, but I don't have any of the fact patterns for that right now. In some of those cases, a lift director was required for the operation and wasn't there, or didn't prepare or assist. It's kind of impractical to be a lift director and not on site if those conditions that Garvin was talking about requires somebody to make those decisions, although the standard does not say that. So I'm going to go along with what Garvin had said. I just looked at the standard to make sure. So what I would say is it's kind of impractical if they're doing those operations and the lift director is not there. It'd be kind of hard to guide the crew if a hazard arose without being there. But the standard doesn't clearly say that the lift director must be there, but it's impractical.
And not to belabor it, but one of the themes of this forum has been standards on the one side, regulations on the other. And I know we have to be careful here because OSHA uses the word standards, for your regulations. So if we're talking about OSHA, let's just say OSHA on the one side and ASME, ASME B30 on the other. I think OSHA has always considered itself a minimum, or at least the industry considers OSHA regulation to be a minimum standard. Obviously, it's the law of the land too, and the voluntary standards as maybe best practices. So it depends whether you're driven by compliance or driven by best practice. And sometimes, you know, that can be decided in a court of law too. So it's, I guess what I'm hearing you say is, you know, this is the minimum, but there's always room for additional action. So, well, thank you for that.
Absolutely. You bet.
Yes. I have one more question on lift director before we leave it. And that question is, can a site supervisor be a lift director? Any thoughts on that? Who'd like to take that one?
This is Garvin again. There's nothing in OSHA standards that prevents them from being that. As long as they meet the qualifications, that's fine. We had many employers, especially the bigger companies, who actually take their site supervisors through a pretty extenuous training program in order to become site supervisors and also oversee crane operations. Those individuals, you know, share both roles. So, you know, there's nothing preventing them from being that.
And from the ASME side, that's the same case. And back to the earlier question, ASME specifically states that the lift director has to be at the job site during crane operation. So for ASME, it's specifically indicated.
Okay. I had a question on the example that we used in the CTAG most similar certification. And somebody actually with some inside knowledge of that particular case, with you recall with the precast launcher and the CTAG determination that the most similar certification was overhead crane. Apparently, I believe I'm stating this correctly, the project owner had shut down the project, believing that until the certification requirements were met, then the project couldn't go forward. And the question actually is there any kind of a grace period where if an employer is demonstrating best efforts, if you will, to comply, that OSHA would be lenient in that kind of situation?
First of all, when a compliance officer, I'm looking at this completely from a regulatory viewpoint. When a compliance officer comes up on a site, determines that they're looking for a fact pattern. And so each one of the decision paths are based on a fact pattern. Based on the question that I had that was posed there, I couldn't necessarily determine whether they were in compliance or not. And in many cases, what ends up happening is when a compliance officer asks, you know, in this particular case, I don't know that it was an OSHA compliance officer, but if they asked for overhead lifting training and they didn't have that, but they did have certification by the manufacturer and were certified. I don't know whether it was an accredited certification or not. That wasn't in the question there. But what I would say is there's a fact pattern that we have to develop to determine whether or not they're in compliance. And in many cases, we would have to determine what the hazard would be. And so it's kind of hard to answer that question as is. But what I would say is OSHA has a responsibility to prove our case. And so if we were to issue a citation either for being non-certified or non-trained per the overhead lift requirements, we'd have to prove that case. Now, I don't know that this wasn't a city inspector or something like that, because sometimes city and local entities have their own requirements that may go above and beyond what we were talking about just a few minutes ago. So that's my answer. Garvin, you have anything to add on to that?
Yeah, just to piggyback just a little bit.
Sure.
As your CTAG group probably understands, these aren't always cut and dry situations. And the question that I would have is, what did the inspector base the determination on of whether this person was qualified for this particular piece of equipment or not, and how the certification that they had was applicable to that or not. That's where we start with trying to be reasonable. The standard really doesn't allow for a grace period though. When it comes to it, you don't put a person in a seat first and then determine whether or not that they're ready to go. All of our standards are written, our modern standards are written heavy on the assessment side, so that you do that up front, you know, before you get in there. So I can't really condone that, you know, a grace period, so to speak, but we would have done some sort of reasonableness to look at what determination that qualified person, made, and based on what, when they did the evaluation of that operator, and, you know, whether or not that certification was applicable to that piece of equipment. Shutting it down is probably going to be on the employer, based on how confident they are that their determination was good. And that's the best that I can say, you know, in an enforcement standpoint.
Sure. But I know sometimes we hear the expression good faith attempt or good faith effort. And I think that, I don't know whether it's officially or unofficially, tends to sometimes weigh in the employer's favor with respect to, you know, citations or so forth.
It would really matter on whether or not there was a serious hazard there, you know, that was posed. Were they doing something that constituted a serious hazard? And that would have to be factored in as well.
Okay. Very good. Well, thank you for that. Let's move on to signal person. We've had a number of questions around the signal person rigor situation. So the first one, and I'm not sure whether this is again for you, Scott, or whether it's Tom or Stephanie, but the question is, if an individual is certified as a crane operator, do they also have to be certified as a signal person?
I can jump in on that. So the answer is no. They don't have to be certified in both. However, the operator does need to understand signals. There needs to be an understanding, but there's a difference between being certified within that versus understanding.
Graham?
Yes, Roy, go ahead.
Just from a certification point of view and not having knowledge in the industry like I would need, you know, you would have to prove if there was an accident, you would have to prove that the crane operators, one of the domains would cover the competencies of a signal certification. So it technically, legally, it could be challenged, I think, if there was an injury, because they could make a case if that domain in the certification for the crane operator is not the same as what you would certify as a signal person, then that's a problem legally.
But I mean, coming back to the certification perspective, that's really why there are two separate programs, right? You talk about domains, which
Exactly.
the uninitiated is subject matter areas, knowledge areas.
This is
Graham.
why when we use terms and regulation and standards, we have got to have a better understanding of what those terms mean. Because we're just loosely putting them out there, and that causes issues when you go to the US court, when there's a court case.
Graham, could I add to the question?
Oh, absolutely, yeah, right. Go
Okay.
right ahead.
If I could, let's make the question this. If there is a certified crane operator, would a certified crane operator be considered a qualified signal person?
I mean, we talked about this extensively during our rulemaking, and Graham's spot on. We have two different tracks for two different reasons. We look at it from a functionality standpoint. And as Scott has said several times, before we would issue a citation under that situation, we'd have to find some deficiency or where that person's certification wasn't adequate and it created a hazardous situation that, you know, that they were actually given the signals. So from a regulatory standpoint, I don't think it's as cut and dry. I know you don't like to hear that, but it doesn't prevent a person from having an operator certification from giving signals, but they have to be functional.
An ASME perspective, and Tom can correct me if I'm wrong, I think, you know, an operator has to be able to understand those signals. So definitely, I would think he would be also a qualified signal person.
I think there is a difference between receiving signals and being able to deliver them, right? And you know, I think that's the key thing of the CCO mobile crane exam was that as a crane operator, you certainly have to understand them when they're given, but you know, I don't think the CCO exam tests you on delivering them. So there is a sort of a gray area in there, which, as Roy pointed out, is important to compare the domains. I do know that there's continuing confusion out there with respect to certification, the terms certification and qualification with respect to operators, and certification and qualification with respect to riggers and signal persons, because the pathways are different, at least as far as the OSHA regulations are concerned. And I think that's probably what's driving some of these questions.
And Graham, as a former aircraft signal person, do a lot more than just signal to the pilot and you know, for the operated equipment. And with an operator, the signal person is in control of what's going on with that piece of equipment and has to be aware of what's going on all around them. Would an operator have that same awareness, you know, just jumping out of the cab and taking on that role on that particular construction site? Maybe not. And so again, we would look at it from a functional standpoint and based on the facts of that specific site.
Right. Okay. Thanks for that. Shifting gears here, somebody mentioned legal areas, and John Zarian, our lawyer today on the panel. John, so you talked quite a bit about testing accommodations. And one of the questions that came up, and you will have heard this one before, is how do you handle requests for testing accommodations, not so much on the written exam, on the practical exam, with respect to, say, requests, operators with prostheses or with one eye, or issues like that. Has that ever come up?
It has, not all that frequently, frankly, but it does come up. And, you know, the bottom line is the operator is required to take the same quote assessment and demonstrate the same proficiency that is required of every other candidate in order to pass. And so, you know, you don't get a certification with an asterisk on it. You get the full certification. So that's the question in each case is, we've had operators with, frankly, monocular vision with one eye take and pass the exam. And so there are those who are able to manage, and it's more difficult, frankly, to give accommodations in the context of the practical. There's less flexibility. We do it much more frequently with the written, but we run it through the same analysis that we do the written exams.
And I guess the issue there is making sure that the playing field stays level, but while taking into account accommodations for folks who wish to be gainfully employed and for no other reason than, you know, their physical disability might be prevented from doing that.
Yeah, that's exactly right.
Thank you. I think this might be, actually, this is a question, Stephanie, for you. Specifically came up with respect to the discussion around the comment you made with regard to the DOT physical exam. The point was made by one of our attendees that the DOT physical exam does not test depth perception. And so it's not recognized by some entities. And the question specifically is, will the new standard take away depth perception as a requirement?
So yes, and Tom can help me out with this because he was actually the one that brought this to the committee to review. But yes, it does remove that requirement. And the intent was that hopefully any of those regulatory bodies will now recognize a DOT physical certification as being ASME compliant.
Excellent. And just remind us when, if you can recall, I don't want to put you on the spot, but in so much as folks out there might be waiting for this to come down as an effective standard, when can we expect that to be in place?
It should be published sometime next year, which means effectivity will be a year after that. So that should be 2022 when it's effective. Okay.
Okay, 2022. Good to know. I'm sure the industry will plan for that. Back to licenses. A reference was made, I think, Vernon, it might have been you, to the federal floor. And I think it was you that said, if the state license does not meet the federal floor, then OSHA will not accept the license as being equivalent to certification. To your knowledge, are there any states that do not meet the federal floor at the current time in their license?
Go ahead, Vernon.
I'm not sure exactly which jurisdictions out there do or do not meet the federal floor. It's up to the jurisdictions themselves to determine that they actually do meet the federal floor. But those things are listed in 1427C of our requirements. We had talked about the idea of trying to keep track of those things within OSHA, but it'd be a bit unwieldy to try to keep track of every local jurisdiction out there, whether they are or not meeting the federal floor. So that's why we have the requirement that it's up to the local jurisdictions to make that determination.
So if I understand your answer correctly, it's up to the, say if you have a state license, you are a state and you have a state license, it's up to the state to self-evaluate as to whether or not they meet the OSHA requirement.
That is correct. Again, that criteria is listed in the standard, and the states can see that criteria and they can make the determination of whether they are or not meeting that requirement.
Okay, all right.
Graham, I'd like to dovetail on what Vernon said. The requirement for that license was to promote, the states to, allow them to meet our standards, so that when the person's working within that jurisdiction, they only have to have one certification. We don't govern the states, so we can't require them to meet our standards under those conditions. And a lot of them, have little subtle things different, but again, when you roll out a rule, it's not going to be perfect, and we're going to have to go through some evaluations of how we're going to make it aware to the public of what they can use to comply with our rules. I mean, there's no getting around that going forward. But as of right now, I'm not aware of any particular state that's just flat out, not in compliance, and that has said that they're in compliance. We're going to have to cross that road when it comes up.
Well, and I think to your point that OSHA was hoping that it would encourage states to bring their programs maybe up to a higher standard, or I think we'd all say a higher standard, because in many cases, some of those states that had programs up in the Northeast did not have practical exam requirements. And so that is a key element in the OSHA rule. And so, and we've seen states do that, right? We've seen some states add a practical exam component to their licensing requirements. Two quite different questions. This one probably is for Bob. It was really prompted, I think, by your presentation on the difference between CBT and paper and pencil. The question really is, you explained it quite clearly as to why that discrepancy occurred, but do you have any experience, if you're comparing really apples to apples, is there anything else there between computer-based testing and paper and pencil testing that anyone needs to know about in terms of ease of passing or components of the test or anything of that sort?
Well, they are, I would say, apples to apples, because the computer-based exams are the exact same exams as the written exams. Now, one very minor difference is that the items are scrambled in the computer-based exam. We do that for security purposes, but otherwise, they are the exact same items. So they really are apples to apples, and that's why we were concerned about the differences in scores and had to figure out why those differences exist.
Okay, very good. Good to know. And then finally, we'll end on a subject that certainly did generate a lot of interest, still does, and I'm sure it will continue to, especially when the compliance directive does get published. And Scott, just before I ask the question, I think OSHA unjustly gets a lot of critique because, it seems like the deadlines keep getting moved, and the compliance directive is really no exception. It seems like it's been month to month and then season to season almost, and I'm sure it's very frustrating for you all. I think it's important for folks to know that this current delay really doesn't have very much to do with OSHA. It's more about the regulatory process that was brought into play by, as I understand it, by the executive order at the end of last year, right before you were due to publish the compliance directive, that slowed things down. Maybe you could just give us 15 seconds on that, if that's an accurate statement.
Sure. Actually, it's a myriad of things. You hit one point there, which was the executive order on guidance. But I wouldn't necessarily say that. I think the biggest component of this, we expected to have this out earlier. When COVID hit, there's a lot of things going on right now with us that we're pushing out guidance and things like that. The priority is COVID. So we're not paralyzed by COVID, but I would tell you that it is the elephant in the room with us. So that's why I put it in my presentation as well. It's an important issue from a viewpoint of how the regulatory process works. It's all resource dependent. So we have had tremendous amounts of resources on COVID over the last 7 to 8 months. And so that kind of put a wrinkle on it, but we're almost there. This directive is coming along very nicely. We had a meeting on it not too long ago. So it's imminent. We just have to right now get in line with priorities and keep pushing this along. And so we're getting close. I'm not going to give you a date, because if I gave you a date, I don't want to be accused of of not hitting that date. And I like hitting dates, trust me. My original date was I wanted it by October 1st, and that was an internal date, and I didn't hit it. So I am working on it. It is my priority. So I want you to know that. I want all of you to know that it is our priority to get this out shortly. I think you will see our FAQs for crane operator certification, as Vernon said. For payment, you'll see a new FAQ coming out very soon, along with a press release, along with an update to the small entity guide. This is all a prelude to the directive. The directive is in the hopper and it is moving, and I'm gonna make sure that it gets out here shortly.
Well, I think the record shows already, Scott, that you do have a good track record of getting things out on time. In fact, I'll tell you, we were taken by surprise when you hit that November date last year. Way to go, Garvin. And I'll be perfectly honest, that was a bit of a scramble. So because we were surprised, but pleasantly. How's that?
Well, what I would say on that, if I can just add in, Garvin and Vernon Preston, they've been there the whole time through this whole process. I came in at the finish line and I helped shepherd it through, but Garvin and Vernon have been there throughout this, and they definitely deserve accolades for that. And I helped them get it across the finish line. So I guess I'm part of that, but I'm proud to be part of that. I'm glad I pushed it through and that we got it done.
That's great. Well, we really appreciate it. So we'll come to the final question, although that was a great point to end on, but it does actually address one of the questions that comes up a lot, and it will be part, I'm sure, of the compliance directive application in the field. People are concerned about the evaluation process and the responsibility put back on the employer, which really never left. I think some folks felt like once certification came along, they were good and done. That was it. They didn't really have to worry too much about anything else, but clearly that's not the case. And we do have that 3-part process now of training, certification, and evaluation. That's very clear in order to be qualified. Folks are concerned about responsibilities of the evaluator when the evaluator signs the document. This is probably really not a question anyone can really answer, because there really isn't a straightforward answer, but I'd be interested in your final thoughts. Anybody would like to contribute to, I guess, really the sub-question, the subtext question is, do I somehow become more liable now I've got to sign off on this as an evaluator? Who would like to take that?
I would say that it hasn't changed. I believe that they always had that responsibility as they were evaluating their operators, even before we required certification. So, I mean, that's just my take on it. Litigation goes in the direction that it goes in, but in general, the things that people are doing to evaluate their operators and make sure that they can do the things that they're supposed to be able to do with the equipment that they're supposed to be able to run hasn't really changed.
And that is a great segue there, Garvin. I would say that OSHA has always held the employer responsibility for the safety on the work site. And holding an individual, we don't really do that. I mean, there may be some cases where litigation happens after OSHA, but the onus has always been on the employer. Just segueing what Garvin said, the responsibility has always been on the employer to ensure that operations are safe, whether it be cranes, whether it be trenching, whether it be scaffolding. It's always been in the area of the employer to ensure that things were done safely.
So basically it comes with the territory, right? If you're going to be an employer, that's just part of the course. It just comes along with that responsibility. So thanks again, panelists. Thanks again, attendees. Have a very safe rest of the day and be well. Thank you again.